Good afternoon, all. This is Rick Hackett, staff. You may begin.
Thanks, Rick. This is Robert Ukaili, Vice Chair of the Board of Adjustments. And this is the January 5th meeting of the Board of Adjustments, and it will now come to order. Due to COVID-19 concerns, this meeting is being held virtually. Information on how to participate in the virtual meeting has been posted on the Board of Adjustments webpage at www.boco.org/BOA. There will be an opportunity to remotely provide public comment on the subject dockets during the virtual public hearing portion of each item. I'll provide instructions about that when we get to each docket on the agenda. I'll now take the roll call. I am Robert Ukaili, Board of Adjustments member, and obviously I'm present. Scott Rudge.
Scott Rudge, BOA member present.
Thank you. George Gerstle.
George Gerstle, BOA member present.
Thank you. And Goldfarb. And you're on mute.
Present.
Thank you. And Sam Fitch.
Present.
Thank you. Reminder to the Board of Adjustment members of the following. Please identify before speaking and speak slowly and clearly. All votes will be roll call votes. Please be sure to have your video on when possible during the hearing. Please remain on mute until you're ready to speak. When you begin speaking, please identify yourself as a Board of Adjustments member. It may help to keep your participant list open in Zoom so you can see who is speaking. The person who is speaking will be bolded. Turning to the agenda items, we have just one item scheduled for today's Board of Adjustment meeting. At this time, I'll take the opportunity to explain the public hearing process. There will be an opportunity to remotely provide public comment on the subject items during the virtual public hearing portion of each item. The order of presentation first will be to hear from staff, then the applicant, and then we will accept public comment from any individual who wishes to speak. Some people may have signed up in advance, although I don't think that's the case tonight, and we will call on those people first. If you did not sign up for public comment, you may sign up in the chat. Please direct all your questions and comments to the board. The chair will direct any questions that arise during the hearing to the appropriate party. Once we are satisfied that we've heard all relevant testimony, the public hearing will close. The board will then discuss the merits of the case and come to a decision. As I was just saying, any member of the public will have a chance to speak, even if you didn't sign up from the Board of Adjustments webpage beforehand. Once those that have signed up in advance have spoken, I will call on additional members of the public to speak. If you joined by computer, please sign up by submitting your first name, last name, and the docket number in the chat box. As each person who is joined by computer and signs up to speak is unmuted. Zoom will adjust the participant status so that you can speak and be seen on video. Once you finish speaking, Zoom will place you back in the room as an attendant. If you dialed into the meeting by phone, please raise your hand by pressing *9, and we will unmute you when we call on you to provide comment. When it's your turn, the system will request that you unmute yourself by pressing *6. Once you are unmuted, please state your name and address for the record before providing comments. Each speaker will be allotted 3 minutes of time to speak. A timer will beep at the end of the speaking time. You can pool your time with other people for a maximum of 10 minutes. Please do not submit comments or questions in the chat box during the meeting. The chat box should be used for public hearing speaker sign up only. Please remain on mute when possible. The moderators will unmute you so that your connection is the source of background noise. Members of the public will be unable to share their screens during public comments. Applicants, please have your presentation pulled up and ready to go. I will announce when we are ready for your presentation, and that time you can share your screen. So turning to the public hearing, this is the public hearing for docket number VAR-21-0005, Cleveland Miller setback variance. Staff, the hearing proceeds as follows. Staff presentation of the staff recommendation, and it'll be limited to 5 minutes. And then we'll have board questions, then the applicant will go, then there'll be board questions, and then public testimony. So at this time, if staff would like to give their presentation, they can do so now.
All right, let me just share my screen. Good afternoon, board members and commissioners, and Happy New Year. Okay, can you all see my screen okay?
We cannot.
You can't? Okay.
Cannot.
Okay, let me try that again. There we go. Can you see it now?
Yes. Thanks.
Okay, great. Okay, so good afternoon. Today I'll be talking to you about VAR 21-0005, Cleveland Miller setback variance at 130 Tall Pine Lane. There we go. So in terms of the vicinity, you can see this is located in the Boulder Heights subdivision, right off of Lee Hill Drive. The project overview, the applicants, Jason Cleveland and Denise Miller, are basically applying for a variance to adjust the side yard setback from 25 feet to 24 feet 6 inches for a detached garage. This parcel is 1.8 acres and it's zoned forestry, again, in the Boulder Heights subdivision. So here you can see it located in the subdivision. Here's an aerial. You can see it's very vegetated on the northern portion and the development takes place on the southern portion of the parcel. In elevation map, one point of clarification that I wanted to throw out there in my staff recommendation, I said that it dropped 1,360 feet over 500 feet. That was incorrect. It drops approximately 160 vertical feet over 500 feet, especially along the eastern property boundary. So please be aware of that. In terms of the site plan, just a few things to note. So the garage is existing and it is 24.5 feet away from the western property boundary, which is not compliant with the 25-foot setback. There are some other constraints in addition to the natural topography of the parcel, and that includes there's a wellhead adjacent to the garage as well as a utility pole. So just a little background on the site history. This the structure was built sometime between 2000 and 2002. It was built without a permit at that time, and obviously also does not comply with setbacks. So just a few photos for you. You can see down looking from Tall Pine Lane to the driveway and then back up the driveway. And you can see the existing garage in the distance there. This is the garage itself from the east. And then this is north. And then you can see the great topographic change that happens on this parcel looking north. And then looking west towards the structure and then away from the structure. This is the closest residence to the structure. And then south and looking from the structure towards the southern elevation. So in terms of referrals, county wildfire team had there was no mitigation required for the variance. However, if a variance is granted and a site plan review becomes necessary, then that will be reviewed further at that time. For building safety and inspection services team, pretty standard requirements for the structure itself. A building permit, plan review, and inspection approvals would be required. For access and engineering, there are no conflicts with the variance. However, the driveway in its current configuration likely does not comply with the multimodal transportation standards. So if the variance is granted and an SPRW, a site plan review waiver, has to be pursued, then it's likely that there may be changes for those future reviews that are required. And then finally, the county surveyor had no issues with the variance and was it's supportive generally of the proposal. I received no concerns or no response from other agencies that were noticed. And then 70 adjacent property owners were noticed, and I've received no comments to date. So then delving right into the variance criteria, the first criteria has to do with exceptional or extraordinary physical circumstances of the subject property, such as irregularity, narrowness, shallowness, or slope. There is a fairly intense slope on this property, and staff does feel that the steep grade can be considered an extraordinary physical circumstance on the subject property. That being said, criteria 2, or B rather, the strict application of the code creates an exceptional or undue hardship upon the property owner. While options for siting the garage are limited, staff does feel that there would have been essentially adequate space available to comply with the regulated setbacks. The third C, the hardship is not self-imposed. As we discussed, the previous owner erected the garage in the setback sometime between 2000 and 2002 without a building permit. This action is in violation of the code, and code violations are inherited. So with that being said, staff finds that the hardship has thus been self-imposed. D, the variance, if granted, will not adversely affect the use of adjacent property as permitted under this code. Staff finds the application does meet this criteria. It's far from neighboring structures, and no conflicts were identified or brought to light by adjacent property owners or referral agencies. E, the variance, if granted, will not change the character of the zoning district. The garage is in character with the forestry zoning district. Detached garages are common for that district, and for the neighborhood in general. And so long as it could comply with an SPR criteria and a building permit, then staff does believe that it is in keeping with the code and the comprehensive plan for anything that would be put there. And finally, the variance, if granted, does not adversely affect the health, safety, and welfare of the citizens of Boulder County. Staff finds that the application does meet this criteria. We have no concerns over the variance adversely affecting the health, safety, and welfare of the citizens of Boulder County. Due to the way that the variances are set up, however, staff has to recommend that the Board of Adjustment deny the application, since all criteria must be met and B and C were found to have not been met.
Thank you for your presentation. Do any of the board members have questions for staff? Board member Gerstle?
Yeah, thank you, and thank you for the presentation. If I understand the implications of the recommendation by staff to deny their variance, the only reason to deny the variance is because of the 6-inch implicit difference in or exceedance of the 25-foot setback requirement. And if the staff is recommending that if the property owner wants to proceed with what their request is, the garage would have to be relocated. Is that accurate?
That's a good question, and thank you for the clarification, Board Member Gerstle. So what staff is recommending denial because it does not meet criteria B and C, specifically for the variance. So our scope is limited today to, and it's a little difficult because the structure is already existing. So it ends up becoming a little bit of splitting hairs. But so what we are specifically looking at within the scope of this is just the variance itself, and whether or not for the actual the setback, it complies with all of the criteria. Since the hardship is considered self-imposed, and this is where it gets a little bit tricky. If we're looking at it as if the structure does not exist, theoretically a variance would not be needed for a structure to exist in the general proximity of that size and scale. They also do not meet criteria B, which is that they essentially wouldn't be able to they wouldn't be able to meet the regulations of the setbacks. So because they cannot meet B and C, that's the reason for denial. Does that answer your question?
But I'm trying to understand the implication of the denial would be they could only move forward with any significant changes on the property if they relocate the garage or buy 6 inches of property from their neighbor. Is that correct?
That's a great question. And so the implication is that if a variance is not granted, then the garage would have to be deconstructed.
Thank you.
Or they can also remove the 6 inches that are built over the setback. But they would still need to get a building permit. But for the purposes of just the variance, and likely go through site plan review waiver, but for the purposes of just the variance, they could just deconstruct that.
Or they could buy 6 inches of property from their neighbor.
Theoretically, yes, I think. Yeah.
Board
Thank
of
you.
Adjustment member Scott Rudge, just a clarification on that. The setback against which they are abutting is to a road, right? Not to a neighbor.
Thank you for the question. No, sir, it is to the neighbor.
Okay, thank you.
And also just a point of clarification for board member Gerstle, they would have to go through a subdivision exemption to change the boundary line for that 6 inches, or rather an exemption plat because it's in a platted subdivision. Either way, they would have to go through a different planning process in order to get that 6 inches.
Thanks. And any other questions for staff from the board?
I have a question. This is Commissioner Goldfarb. So you're recommending denial because it doesn't meet 2 of the criteria. Are we bound by the fact that it doesn't meet the 2 criteria, so therefore we must deny?
That's a great question. And I would, Erica, I see that you're on the line. Is there any chance that you could answer that? I want to make sure that the language that I give you is correct.
Sure.
Well, sorry to interrupt, but if we want to ask for legal advice, there's like a specific way that we have to do that. Is Commissioner Goldfarb, is that what you, well, Larry, would it be okay?
Yeah, Mr. Chairman, Erica is the attorney for the planning department for community planning and permitting. So she can assist the staff in providing answers to questions. And she's not providing legal advice necessarily to the board, just stating the position of the planning and permitting department.
Okay, thank you.
And hi, this is Erica Rogers, Assistant County Attorney, and I can just refer to the code 41202B2, which says in order to grant a variance, the Board of Adjustment shall find that the following criteria have been satisfied. And the way that staff has interpreted that is to mean that all criteria must be met in order for in order to recommend approval of a variance.
Let me ask a further question. So whenever, and I apologize because I'm not a member of the Board of Adjustment, so you all may know this, but if someone requests a variance, does it require that come to the Board of Adjustment, or can it be denied by staff?
Variance applications are required to be presented to the Board of Adjustments. It wouldn't be denied by staff, and staff's position is a recommendation to the Board of Adjustment. The Board of Adjustment makes its own independent determination of the extent to which the criteria are met and whether the variance should be granted.
And if we allowed the variance, what would happen then?
My understanding is that this situation would then have to go to a site plan review or site plan review waiver process in order to proceed.
Okay. And what would that entail? Just for the record, so we've got that there.
I think community planning can probably answer that better than I.
This is Staff Planner Sparks, if I can just take over briefly. So also in the staff recommendation I provided, that I provided 3 conditions of approval should the Board of Adjustments or recommended conditions of approval should the Board of Adjustment choose to approve the application. And those are the the applicants have actually already started a site plan review waiver. So it would be completion of that site plan review waiver, any applicable and necessary building permits. Those are both for the detached garage, and also that basically no, that any future development is not given an automatic variance of that kind, if I, just to put it briefly.
Thank you.
So this is Commissioner Fitch. I'm the substitute commissioner from the Planning Commission. But I have done this before, and there was a prior issue where exactly this question came up. Staff recommended against, and I voted against, because the question of self-imposed, the hardship being self-imposed, resulted in a staff denial, but the vote of the Board of Adjustment at that time was a majority in favor of saying that despite that issue, the variance should be granted, because not granting it would result in outcomes that were in fact contrary to the goals of the comp plan. And at the same time, nobody was being adversely affected. Nobody and no comp plan goals were being adversely affected by not granting the variance.
Sorry to interrupt, but can we just limit it to questions at this point, and then we'll
Sure.
get to discussion? Thanks.
Okay.
So are there any other questions from the board members for staff? Going once, going twice. Okay, thanks. So next we'll hear from the applicant.
This is Anna Milner, staff. The applicant has just been promoted and they are now with us. Hello, Jason and Denise. You're welcome to show your video. There you are. Thanks.
Hello, good afternoon, board members, and thanks for hearing this. I do have a couple slides I can share if we need them, but I think I can just briefly address the two criteria that staff had thought we failed on. The first one, I think, it really sounds to me like a question of legal fact. We recognize that we bought the liability. Our research did not unearth the flaw, so that's on us, and there's really nothing we can do to correct that besides asking for your consideration. And then as to second, I think technically it is true that you could fit an equivalent garage on the site somewhere, but due to the grades, it would be a garage built on a very steep slope, either above the house or below the house. So that's probably either a two-story garage, a garage with deep footings into a steep slope that's cantilevered out, or a lot of fill to go in there. And we haven't gotten any quotes on that. I'm guessing with current building prices, that's probably a six-figure garage we're looking at. And so I would view that as a hardship. So there I do have a different opinion with the staff, but that's really, unless you want to look at the site plan and sort of see where equivalent garages could drop in, that's mostly what I have. And again, just to reiterate, we bought the liability. The sellers or their agents did not disclose it. They claim to this day that they permitted it. We don't believe them. There's probably, there will possibly be mediation or litigation depending on how this goes. But they could not produce anything proving that they had permitted it, and the staff was unable to find anything. So I'll just leave it at that unless you want to look at the site plan again.
Thank you. Do any board members have questions for the applicants? So I just had a comment. In your letter, you mentioned that you talked to the neighbor that is on the side where it goes 6 inches in. And I just wanted to say that I appreciate that the Board of Adjustments and the Planning Department exist, but it's always best to have neighbors talk to neighbors about concerns. So I did want to express my appreciation for that.
Thanks.
For
Yeah,
that effort.
he's a great neighbor and has shoveled our driveway with his Bobcat occasionally. So we're happy to have him.
Thank you. So, if there are no other questions for the applicants, we can move on to public testimony. And I will turn it over to Anna for that.
Thank you. This is Anna Milner, staff. There's no one currently signed up to speak, but I do see a phone dialed in. If you are interested in speaking at this time, you'll need to press *6 to unmute yourself. I've already allowed you to talk. If you're not interested in speaking, that's fine, but we'll give you a minute to press *6 and unmute yourself and speak if you'd like. One other note, if you're having technical issues, please press *9 to raise your hand, and that will alert us if you're not able to speak via phone. Thank you.
Okay, I'm gonna assume that that person does not want to offer comments, and so we'll move on. So I'll offer one final opportunity for the board members to ask any questions of staff, the applicant, or any of the speakers.
BOA member Scott Rudge. Chairman Ukaili, shouldn't you offer staff an opportunity to rebut whatever the applicants said, as little as it was?
I think that comes next on the agenda.
Okay. I'm ready for that.
Thanks. Okay. So then, as board member Rudge just mentioned, I'll offer an opportunity for staff to make any rebuttal or clarifying statements.
Staff has no further comment. Thank you.
Thank you. And then I'll offer the applicant the opportunity to rebut any comments made by the public or staff.
Yeah, we don't have anything further. Just given it 6 inches into the setback, we appreciate your consideration in the matter. Thanks.
Thank you. So that concludes the public hearing, and we'll now move on to board discussion. So I will ask the board members for their observation, discussion, and conclusions about the required criteria based on the testimony and the documents presented. Board member Bristol.
George Bristol, BOA member, right? Yeah, I would like to hear Commissioner Fitch's completion of his comments on his experience, if that would be acceptable.
Yes, and I'm sorry if I cut you off before. I just wanted to make sure we're, complying with the structure set forth. So
So this is Commissioner Fitch again. Uh, And I guess my previous comments were that on my previous last appearance as a substitute member of the Board of Adjustment, we had a similar case in which somebody had bought a cabin that had burned down, and the question was, could the current owners use that site even though it was far closer to the property line than the setback would have required? The Board of Adjustment majority at that point took the position that it was possible for the Board of Adjustment to approve a application for a variance, in this case, again, of a setback, on the grounds that granting that variance did not adversely affect any neighbors, any particular goals in the comprehensive plan or not. And on that basis, the fact that it was, as in this case, a bought property that had a non-complying setback was not something that really denied. So in that case, they had a whole lot to put that, a fairly flat lot, to put a new foundation in. But it would have probably doubled the cost of the cabin they were trying to rebuild. So there was substantial hardship to the owners of that property if the setback variance was not granted. And the point was, what, as members of the Board of Adjustment argued against a strict application of the criteria on the grounds that comp plan goals would be better served by letting that variance go ahead. In this case, it seems to me that the variance requested is quite small, 6 inches in a 25-foot setback, and that nothing is really gained for environmental goals or land use goals. And in fact, requiring them to deconstruct the current garage and replace it with something somewhere else in the site is going to result in more disturbance of the land. It's going to result in energy cost. It's going to result in wasted materials. So if there's nothing to be gained for the comp plan goals, in this case, I will vote for conditionally approved with the 3 conditions that staff has recommended in case we decide not to follow the staff recommendation.
Thank you. I would also offer that I'm in favor of granting the variance. There's a legal doctrine in our law that's existed for a long time that says the law does not take account of trifling matters. So in this case, it's 6 inches and it's an existing structure that has existed for, as far as we can tell, approximately 2 decades. And so I do think in that context, this is a trifling matter. And applying that doctrine here, I think it's appropriate to grant the variance. In the interest of time, I have a sense that we can move forward. So, Commissioner Fitch, would you be interested in making a motion, unless any of the other member strongly, okay. Board member Raj, would you want to speak before we entertain a motion?
Yeah, just briefly, it's Scott Rudge, Board of Adjustment member. Thank you, Chairman Ucali. I believe that I'm the only other board member present who is on that case that Commissioner Fitch remembers. I remember it as well. I just want to put a little pressure on Commissioners Goldfarb and Fitch. As a result of that case, the Board of Adjustment attorney, Larry Hoyt, asked us to compose a letter to the Boulder County Commissioners asking for the leeway when environmental concerns are served. Can we grant variances? So in the case that Commissioner Fitch recalls, our main concern was bringing construction equipment, building a new foundation in unspoiled virgin area. It just didn't seem to serve anybody's purpose. I mean, the cost aside, it didn't seem to serve the purposes of the comprehensive plan or anybody really to force somebody to do that. And I believe that's the case with Jason and Denise here. So I'll vote that way as well. But we've waited quite some time for a response to that letter, and it would really make our jobs clearer if the Planning Commission would give us some feedback on that letter. We've had other cases in the meantime that could have benefited from that abeyance on your part, and getting that clarity from the Planning Commission could really assist the Board of Adjustments in doing, I believe, better work than we've been doing over the last year and a half. Thank you.
Thank you. Does
This is-
anybody else want to, Commissioner Goldfarb?
I just wanted to respond to the issue of the letter, and I'm unaware of any letter. I don't know about Commissioner Fitch.
This is Larry, this is Larry Hoyt. The letter that was sent on behalf of the Board of Adjustment was addressed to the Board of County Commissioners because they're the ones who would have to initiate a code change that would make this process permissible.
Okay, yeah. Thank you.
So this is Commissioner Fitch again. I would like to make a motion, but I also want to amend the usual language to make it clear on what grounds we are, or I would propose that we make grant the variance. So this would be the Board of Adjustment approves VAR 210005 Cleveland Miller setback variance. But then adds the language, finding that the setback variance in this application is small relative to the required setback, and finding that granting the variance requested would not contravene any comp plan goals, and finding that not granting the variance requested would run counter to comp plan goals regarding energy conservation, energy and resource conservation. So we're recommending approval with the staff recommendation in the packet for 3 conditions. One, that the applicants are required to complete the applicable site plan review waiver. 2, that a building permit is required for the existing detached garage. And 3, that any future development is subject to applicable planning review and permitting.
I would second that motion. This is George Gerstle.
Vice Chair
You're
Ukiele.
muted,
Commissioner Gold.
Commissioner Ukulele.
Okay, sorry about that. I just wanted to clarify the third recommendation.
I'm sorry, now you can hear me? Yes?
I didn't get, could you try again?
Me,
Can you
is
hear me?
George Gerstle or? George Gerstle. George Gerstle seconded the motion.
Yeah, can you hear me
Yes.
now? Oh, okay.
Yes.
I don't know what happened. It cut out at me. What I was trying to say was I would like to make an amendment to that motion.
Okay, well, there's. All right, what would your proposed amendment be?
My proposed amendment would be to include as another basis for granting the variance that this is a de minimis violation.
Thank you. Anybody want to second that proposed amendment?
Scott Rudge, Board of Adjustment member. I would like to second that amendment.
Okay, thank you. I also would like to propose an amendment, just the third recommendation from the staff on page 5. It also says, I believe the amendment, or sorry, the motion said that any further development is subject to applicable planning review and permitting. And the staff recommendation also said, and setback requirements. So I wanted to make that clear. So I would propose to just make sure that we include all three. Does anybody want to second that amendment, and then we can vote on the amendments?
So
I would
this,
second amendment.
Thank you. Okay, so let's first vote on Commissioner Goldberg's proposed amendment. This is Board Member Robert Ukiele. I vote aye. Board Member Rudge,
Scott Rudge, aye.
Board Member Gerstle,
George Gerstle, aye.
or Commissioner Fitch,
aye.
Commissioner Goldfarb.
Aye.
Thank you. So that amendment passes. And then we'll vote on the amendment to add the additional language about setback requirements that appears on page 5 of the planning, or the staff packet. This is Robert Ukiele, Board Member. I vote aye. Board Member Rudge,
Scott Rudge, aye.
Board Member Gerstle,
Aye.
Commissioner Goldfarb,
Aye.
and Commissioner Fitch.
Aye.
Thank you. So now we'll vote on the original motion as amended. This is Board Member Robert Ukiele. I vote aye. Board Member Rudge,
Scott Rudge, aye.
Board Member Gerstle.
Aye.
Thank you. Commissioner Goldfarb
Aye.
and Commissioner Fitch.
Aye.
Thank you. So the variance is granted pursuant to the motion as amended.
So this is Commissioner Fitch again. I do think I'm not knowledgeable about the particular content of the letter from the Board of Adjustment to the county commissioners, or to why the commissioners have delayed responding to that letter. I do think, again, that Planning Commission and the commissioners should go back to the question of, again, how we respond to de minimis setback violations, how we assess those, and what constitutes particular self-imposed, the language regarding self-imposed hardship when people buy properties not knowing that they in fact have an unpermitted structure or use on that property. So I think those are things which can go back to for discussion, maybe jointly between the Board of Adjustment and the Boulder County Planning Commission.
This is Scott Rudge, Commissioner Fitch and Commissioner Goldfarb. I appreciate anything that you can do to give us some more clarity on those purposes of the Board of Adjustment. Because that guidance would be invaluable, I believe, and would help us be more consistent, I think, as the members of the Board of Adjustment change from year to year.
This is Commissioner. Oh, I'm sorry. This is Commissioner Goldfarb. I'm wondering whether this is a question for Erica Rogers. Procedurally, is this something that we can ask you in the county attorney's office and or staff to look into, to present something to us so that we could have that discussion?
Hi, this is Eric Rogers, Assistant County Attorney. I think that it's something that we should discuss with staff and figure out the best way forward. I'm not exactly sure. I think the letter was sent before I started here, so I don't know all the history on that. And but I do think if Kim Sanchez were on, she would probably have more information about that. And I think she's spoken to it before. So maybe we just need to huddle up as a staff and get a little more clarity onto the status of that.
This is Commissioner Goldfarb. I see Summer here. Did you have something, Summer, that you wanted to add?
No, actually, Erica covered it quite well.
Okay.
Staff, we certainly have heard what the discussion today, and so staff can take this back and, as Erica said, huddle up and figure out what the status of that letter is and what the most appropriate path forward is to have the discussion.
Great, thank you.
I would like to underscore the need to have the conversation and make sure staff does not put it on a low priorities.
I would agree with that.
Thanks, everybody. So at this point, I would ask for a motion to adjourn the meeting.
So made, Scott Rudge.
And second, is there a second?
Second.
Thank you. This is Robert Ukaili. I vote in favor of adjourning. Board Member Rudge.
Scott Rudge, aye.
Right.
George Gerstle votes aye. Commissioner Goldfarb
Aye.
and Commissioner Fitch. Thanks, everybody, and I hope you all have a happy and healthy new year.
Thank you.
Thank you.
Thank you.
Thank you, everybody.
Thank you.
Bye.